And your 60 minutes start running from now.
Thank you, Mr. Speaker. Mr. Speaker, honorable senators, my colleague, for the record, my name is Wajiko Diongo. I will commence the closing argument, then my two colleagues will come thereafter. Honorable senators, our point of departure is the sequence of events as prescribed under Section 33 of the County Governments Act. And definitely, as we sit here, it's not in dispute that the County Assembly has the jurisdiction, the first jurisdiction or the first instance in moving a motion for the impeachment of the governor. However, Mr. Speaker, in doing so, they must do so within the confines of the law and the edicts of the Constitution. They must adhere in the very least to Article 10, the principles and values of governance, and must do so within the provisions of Article 181. Therefore, before this House can admit this motion, it must then be satisfied, as we raised in our preliminary objection, that the threshold of the 2/3 majority of the Assembly was met. But in determining this question, serious issues have been raised on what transpired in the Assembly on that day, Mr. Speaker. Several clips, videos have been played in this House on what transpired. And what can be seen is that from those videos and the picture which has been painted is that for the first time, the Kericho County Assembly introduced electronic voting system. The MCAs had never been trained about this system. It has not been controverted by our colleagues from the side of the Assembly. It's also in addition that it is on the floor of that motion that the Speaker of the Assembly informed the MCAs that now the electronic voting system had been deployed. From the ICT officer of the Assembly, Mr. Alfred Kimtai, Mr. Speaker, when that question was put to him, he admitted that the system was deployed 2 days before. The MCAs had not been given an opportunity to interact with the system, create their own passwords, so that the vote which they are going to cast is going to be linked to a particular MCA. This goes to the verifiability of that particular vote. It is not about the numbers at this point. It's about the process within which that election was undertaken. Because an election is not just an event, it's a process, Mr. Speaker. It can also be seen from those clips which have been played in this House that there was a division in the Assembly. And when there is a division, the standing order requires that a roll call vote is taken on that issue. The issue was raised by one Gabriela, who has been called as a witness before this House, and was supported by 17 others, making a total of 18. And it is at that point, the standing order number 79, honorable senators, that required the Speaker to direct a roll call vote to be undertaken on that issue, Mr. Speaker. However, the Speaker of the Assembly instead went on to declare that the voting was going to proceed electronically. It is not clear why at this point, for a matter of this magnitude, because as we sit here, the decision that is going to be undertaken, that was undertaken by the Assembly, is going to take away the political right of the governor, because he was declared as the duly elected governor. But on the same breath, is going to take away the decision and the will of the people of Kericho County. So that a matter of this magnitude, it has not been explained by the Assembly why was the rush to use the system, which was being piloted for the first time, to vote on this motion, Mr. Speaker. And looking at that system and the various questions which have been raised by the honorable senators, it's clear that the system had serious doubts. There were serious issues of manipulation, and the three ICT experts, as they came here, they could not clarify or clear the doubts which were raised by the senators. There was issues which were raised about the geographical location of the particular votes. And as we stand here, every vote could not have been linked to the geographical location. And the answer is one. The configuration or the manner in which the system has been set does not secure the votes. Mr. Speaker, it is also admitted, it's not disputed, that on the material day, I have heard the counsel for the governor indicate that the username is like the email address, and the password was unique, but in this case it was an ID number. How many times do we sign with our ID numbers when called upon? It is clear from the list of even the laptops that was applied to them that they had to write their own ID numbers. As they sign various registers, Mr. Speaker, they had to indicate the ID numbers. So what is unique about the ID numbers when we talk about a password? And it is clear from the 3 ICT experts that the two-factor authentication or the multi-factor authentication was not created for this system, so that every particular vote can be linked to the MCA. Also at the same time, from the Hansard at page 195 of the governor's BADO, the Speaker himself of the Assembly publicly announced that the ID number is the password. So it was no longer a secret of what the password was, Mr. Speaker. And at the same time, issues arose about whether the MCAs had brought the tools of trade, particularly the gadgets which were required to conduct business. But as it has been shown, is for the first time they were going to use electronic voting. No prior notice had been given to the MCAs, and that was declared on the floor. So that when the MCAs have given evidence that they did not have their phones, they cannot then be faulted, because in the normal conducting of their business back in the Assembly, it is for the first time that they were required to use their phones. Mr. Speaker, it has also been shown also about the user name, which is not disputed, that the first link had all the usernames. And every MCA had access to the link and could then access the username or the IPPD address for the MCAs. And with that, Mr. Speaker, the case for the Assembly is that 3 voted. But the question the House should ask is the verifiability of these 33 votes. Can you link the vote of each and every which was casted or which is said to have been casted to the particular MCA? It has also been admitted that the MAC address for the devices used in casting these votes could not be submitted to this House by either of the ICT officers. And with that, even as we narrow down, on the governor's side is that 18 MCAs did not vote. And narrowing it down is that there are 4 disputed votes in this case. That's the vote of Martin Kiprangat, who testified yesterday. We have the vote of Kibet Mosuben. We have the vote of Amos Biril and Edna Chepkirui. And just to attempt to address the issue of Edna, she has 2 conflicting affidavits. And as the Assembly is faulting the governor's side for not calling this witness, they have equally not called her to come and produce this affidavit. And as such, we are left at a point whether indeed she did sign that affidavit with the Assembly. But also we have the clip of Kibet Mosuben, which was played where he received a call from Mr. Logon, who was the motion mover. And the best defense the motion mover would give was that that's not my voice and I do not drink. But he has not given controverting or evidence to controvert that evidence. He has not given his call logs to say, on this particular date, I did not call Honorable Kibet. He has not controverted that clip apart from just denying, which is so easy to say, that's not my voice as it is, even when clip has been played. And so that, Mr. Speaker, as I wind up, from the system, with all these doubts being created, the ICT officer from the Assembly could not supply the system security certificate for this system, could not supply the penetration certificate for this system. He also admitted there was no personalized password which was created for every MCA. And what was available as the password was the ID which was available to other third parties. So that the question then the Honorable Senator should ask, how secure was the system? And how verifiable is the vote which was cast? Honorable Senators, as you look at the affidavit of Mr. Alfred Kimutai, the ICT officer, at paragraph 23, 30, 31, and 32, it is his admission that the system designed is very simple, accurate, verifiable, secure, and user-friendly. However, with the doubts which have been created about the system, has it met those standards? But also in the same breath, even after this House, let me use it on a right note, ordered for the server to be opened, and the ICT experts had to testify, it has created more doubts than answers to these honorable senators about the verification of the votes and the security of that system. And it's not even in any way comforting. But if that doubt then is there, and the verifiability of the votes cannot be proven, the integrity of the system cannot be proven, it cannot then be said the 2/3 threshold was met. And it is thus our submission, Mr. Speaker, that the jurisdiction of this House has then been prematurely been invoked in this case. And the charges and the motion by the Assembly should not be admitted. Thank you. We can have my senior pick it up from there.
Mr. Speaker, sir, and the Honorable Senators, allow me to pick up from where my colleague has left and complete our submissions on the questions of the ICT issues raised in these proceedings. And simultaneously, when addressing that question, I'll be principally making submissions on our preliminary objection. The question of threshold, and the most important thing is whether we have information before this House on whether 33 MCAs actually voted of necessity, provide the basis for this House to make a decision. Allow me to first of all say that as lawyers, we are not experts in IT. Throughout these proceedings, myself, it's been a learning experience, and up to now, I can say without contradicting myself that I know where the problem is, and I know then in terms of the decision on what went wrong, the vulnerabilities of the system, the missing gaps, the information which is required for purposes of making submissions before this Senate. And it is important to just highlight as a way of reaction to what the learned Ongoya said with respect to lawyers providing evidence. That is not true. This is a house of record. It's a house of evidence. What happened, Mr. Speaker, Madam Speaker, what happened is that the County Assembly created what we call a demo website. A demo website 2 days ago. And at that demo website, for us who are participating in this impeachment process, based on the information which was available by the County Assembly in Volume 4A, and that is where I'm going to focus my submissions on. Based on the information available, publicly available, and that's one of the issues which we have demonstrated here as a major vulnerability of this process on the aspect of verifiability, accuracy, and authenticity of the system, confidentiality and data protection, which has a heavy constitutional implication. So one of the, if you look at page 1 of volume 1, volume 4A, if you look at page 1 of volume 4A, there is information which I accessed and which was accessible to anyone at the County Assembly and all the MCAs at that time. The information is the IPPD numbers of the MCAs. That was the username which was supposed to be used to access this site, and that has been confirmed by the testimony of all the expert witnesses here. And the three of them, from the County Assembly, County Executive, and Office of the Governor, and the expert witness from the Senate. Then this system, how do you access it? You access it using an ID number. Again, from the ICT policy and the best practices in in software development, we have been told that it is not a proper security safeguard to access such a system with an ID number. So what happened is that the county assembly 2 days ago created a demo website. So with this information that is easily available, it was then possible for anyone to key in and access that system. So it begs then the question, because the ID numbers are contained in volume 4A, that is page 1. The IPPD numbers are in page 4. And it begs a fundamental question which it keeps on recurring in this House, even from the questions which have been asked by the senators and the responses which were given by the ICT expert from government, from the ICT authority. This information, we request the Senate to take judicial notice of the information contained in an IPPD number. Who else can access that information within a county government setup? Payroll staff in the county government, county assembly can definitely access the payroll number for the MCS. The persons who created this system, the IT administrator, and the evidence has been laid here, clear, express, and unequivocal, that a link was sent to the administrator of this system. So he also had access to this system. The other persons who had access to this system are any person then who had mischief. Any person who had mischief will then access this system because it's data that is easily available. So that concern, we are saying, is an important aspect which you need to consider when making your decision on the question of threshold, which is a requirement of Section 33, Paragraph 2 of the County Government Act. Because the meat of this matter, the substance of this matter, the question that is before the Senate for determination is whether 33 MCS actually voted. Secondly, whether the 33 MCS met the constitutional threshold. Thirdly, whether the 3 MCS who claim that they were not, they did not vote, but someone voted for them, whether that evidence is credible, and if that is accepted by the Senate, then it affects the threshold. It affects the threshold. It means then there is no proper motion before the House, and on that basis, based on the legal doctrine that the law matters, that county assembly as a house is also governed by the law. We can do what we want, yes, but we must follow the law. We are all servants of the law. It is the law that drives everything that we do, including proceedings that are conducted at the county assembly. So that in this case, the Senate has a duty and an obligation to verify the authenticity of the 3 votes, because they will bring down the threshold, and then it means, and based on the ruling which was issued by the Speaker yesterday, that when voting on that question, if you believe that the 3 MCS, including Honorable Trump, did not vote, and remember, these MCS have come to the House. They have come here and told you by their word of mouth that I, Honorable so-and-so, I did not vote on this motion. And there are 3 of them. And their testimony is consistent with what transpired in the House. The question that you'll be left with is, do you believe these MCS who said that they did not vote so that you can make a decision on the threshold? Or do you believe a computer-generated information which has so many doubts to the extent that the entire House is asking questions? The question which this House is asking, and which all the senators have observed are asking, is really fundamental. We cannot put this down there. We are not downplaying the allegations against the governor. We have responded to them. But what we are saying is that did these 3 MCAs vote? What does the evidence tell us? Let's look at the evidence. Where is the evidence? If you look at, Mr. Speaker, the evidence is contained in volume 4A. Evidence has been led here by experts, all of them, that when you vote using a gadget such as a computer, which is internet enabled, when you vote using a laptop or a tablet or a desktop, there are unique codes that identifies that gadget in the system. This code is known as the MAC address. When you sign into the Wi-Fi, using that gadget, it will leave a digital fingerprint, a digital print, digital evidence on that system for purposes of anyone who then audits that system, checking and ascertaining that MCA A, B, C voted in that system. So that is a fundamental question that we must always ask ourselves when we are determining that preliminary, voting on the preliminary objection. Is there information before this House? Mr. Speaker, sir, when I asked the government ICT expert a question, deliberate question, it is because of that. Because yesterday we were with this ICT officer. We were raising concerns about various things. One, whether the ICT officer from the ICT authorities can be able to comprehensively answer all the questions with the information which they have. We asked the question which was asked by a senator here, whether they can be able to hack into the, do a soft hack. It's called a soft intrusion. Whether they can be able to hack into the system to verify the identity of the MAC addresses, to get those logs. We asked that question, and then the ICT officer walked out for 2 hours, and then came back. So we were appreciably apprehensive. What did this ICT officer go out to do for 2 hours? From between 2:30 p.m. and 4:30, after the speaker had issued directions that we need to be there and ensure that this audit is done and it's a time-bound activity. Why would he do that? So we were appreciably apprehensive. When the ICT officer came back, and if you look at the report which he has submitted, he did not want to explain. His approach was that yes or no. The speaker has said, is it verifiable or not? Then he said, I will respond to the question the way I want, yes or no. That's what happened. That's what happened, yes or no. That's why if you look at the report of the ICT officer, and if you look at the report, it does not contain the information which we asked him to put on the report, which this Senate has been raising this afternoon. That evidence of the MAC addresses. We told him, and he has confirmed here, we told him, why can't you simply say in your report that for you to verify that MCA A, B, C, and D voted, you need their MAC addresses of the gadgets which they used, and these MAC addresses are in the system. And then he told us orally that this MAC addresses, yes, you need them, but I will not put them in the report. Mr. Speaker, sir, that is the context in which the governor side said, then we cannot sign this report. Even though they participated in the report generation, they were there when the logs were being extracted, the logs which are in the report. Those logs, same logs are in the county assembly document, and these logs will tell you only one side of the story. They will tell you only one side of the coin. Only one side of the coin. And it does not answer the question which is before the Senate. Which is this side of the coin? That 33 MCAs voted. Mr. Speaker, sir, let me say here, as part of our submissions, in a very, very clear and succinct manner. Indeed, we have looked at the evidence submitted by the county assembly, the data generated from the system, by the county assembly, and as extracted by this, by the expert speaker, the expert witness, and the expert witness also of the governor. And there is information that 33 MCS actually voted for this motion. There is information that 33 MCS voted for this motion. It is there. It's there in page 4A. But the fundamental question, because the governor's team is saying, so and so did not vote for this motion. And there are 3 of them. So the question then that begs the answer, which all the experts have not answered to now, which leaves doubt in the minds of everyone, including myself as a lawyer. Where can you with certainty tell us that this MCA, that MCA for this particular ward used this gadget to vote? Because then that will weed out. It will weed out and completely foreclose, Mr. Speaker, sir, the statement, the oral evidence which has been made by these MCAs. Because these 3 MCAs are saying, I did not vote. I, Honorable so-and-so, I did not vote for this motion. I did not vote. Mr. Speaker, sir, that statement is extremely weighty for purposes of the proceedings in this House. Therefore, we ought to have gotten from the system logs of all the MAC addresses of the gadgets which access this system from the county assembly. To leave that doubt, to leave that question clear to the minds of everyone. Mr. Speaker, sir, additionally, yesterday there was evidence which was led that some MCAs could not vote using their gadgets, their telephone numbers. Their telephone numbers. Sorry, their mobile phones. So what happened is that the clerk, the speaker asked them to be assisted to vote using a machine, laptop or desktop, but it was a computer. That evidence will be there to be analyzed. The MAC addresses for that system. The ICT officer from the government says that that evidence ought to be in the system. We consistently asked him this question deliberately because we want that question to be fully answered. Where are these MAC addresses? So, Honorable Senators, as we retire to consider this, the question of threshold, just know that there is now doubt more than ever. Experts have come to the Senate and there is doubt from all of them on the existence of these MAC addresses. Instead, Mr. Speaker, sir, Mr. Speaker, sir, this is really interesting. Instead, they say, especially the expert from government says, that what we have as evidence are the IP addresses. The experts who, including himself, say that for it to be complete, you need to have both the MAC addresses and the IP addresses. The IP addresses is, what did he say, Mr. Speaker, sir, when he was testifying here? He said that the IP addresses are the gateways, the gateway IP addresses. They cannot tell, it tells you who accessed a particular Wi-Fi, which was being used by the MCAs in that area. It does not tell you the MAC addresses of the specific telephones that were used. So that is very, very significant. So to complete that argument and to leave no doubt whatsoever, if you look at volume 4A, and here, Mr. Speaker, allow me to just address a couple of issues on volume 4A. That is at page, the IP addresses which were produced. And the experts say that this is not conclusive. You will need additional information. At page 29, 31, 32, 33, of volume 4A. The Honorable Senator Asige, I don't know whether she's here, probably listening to where she is, asked an extremely important question, Mr. Speaker, sir, which affects the aspect of verifiability. Verifiability. Even on these IP addresses, we have left the issue of the MAC address, of the MAC addresses. Let's look at these IP addresses. I listened to the Honorable Senator Asige asking that question, and I said, maybe that is the real issue that the Senate also need to inquire about. What was the issue? How many Wi-Fi? They say that if you have a gadget and you access the system, you will use a Wi-Fi. That's what they said, Mr. Speaker, sir. Is that right? Yes. They say that then 9 MCS can have the same IP addresses because they access the same Wi-Fi. Again, that's what they said. I'm not picking this from there. Statements from the word of mouth. So the question is, if you look at these 33 IP addresses at page 29, page 32, page 29, 30, 31, 32. Mr. Speaker, sir, look at these IP addresses. Are these IP addresses the same? Mr. Speaker, sir, there are some which are the same. And this was pointed out. There's an IP address which features really prominently. It appears 9 times. This is 41, 139, 237.129. This IP address appears 9 times. 9 times. The ICT experts who appeared here say that it's also possible to do a geographical search of these IP addresses. But there is no evidence in the Senate that a geographical search of these IP addresses was done on the aspect of verifiability. But this IP address appears 9 times. So what does it mean? That somebody accessed, they accessed a particular Wi-Fi 9 times. But Mr. Speaker, sir, if you look at these logs, you will see that there are many other IP addresses. So the question is, why are these IP addresses different if you are all within the county assembly premises, the house? You are accessing the same Wi-Fi network. And they say that if you access the same Wi-Fi network, then you need to have the same IP address. So the question is, why are these IP addresses different, Mr. Speaker, sir? Is it possible that the Kericho County Assembly has 6 Wi-Fi routers? Because when I counted, I saw. And Mr. Speaker, sir, you can count for yourself the different IP addresses that appear in this document. And that was the query which was raised by the distinguished Honorable Asige. So, Mr. Speaker, sir, we submit that we have a very big problem before this House. The problem is that there is no certainty whatsoever based on the testimony of the 3 expert witnesses on who actually voted. Their votes are there, but who actually voted? Instead, Mr. Speaker, sir, the possibility is that somebody may have accessed this publicly available data and voted for anyone else. And that is the information which, that is the evidence that is before the House. And because of time, Mr. Speaker, sir, allow me to then conclude by saying that based on the provisions of Article 10.2 of the Constitution, the system which was deployed by the County Assembly on this vote, Mr. Speaker, sir, on an important matter concerning the removal of a governor from office. That system is not transparent, it is not verifiable, and therefore the results from that system are not verifiable. And on that basis, Mr. Speaker, sir, I urge I urge the honorable senators, Mr. Speaker, sir, that you allow our preliminary objection and throw this issue back for the where it came from, because it does not meet the constitutional threshold as required by Section 33(2) of the County Government Act. I yield the floor to my colleague.
For the record, my name is Katwa Kigen, counsel for the governor. And the nature of my submissions will be more towards the aspects of fact. And Mr. Speaker, sir, and honorable senators, we hold the position that the governor has responded to the factual allegations of the claims made by the County Assembly, and that is captured in his affidavit, volume 1, the affidavit in volume 1, page 1 to 31. And the allegations that had been raised by the County Assembly are 9, and all of them have been answered. It relates to management of a program called NAF-CDP, FLOCA, Kasim Tani, Strategic Intervention Projects, Londiani accident, dismissals, subversion of County Assembly activities, and bullying. All those issues we've answered, and we pray that the senators and Mr. Speaker, sir, they be looked at as answer to the allegations. Now, in more particular, I would like to say this. The allegations are in 2 categories. The first category is old complaints that were brought here before you in September 2024. And the second set are new claims raised by a report made on 5th of August 2025, and attendant to which an impeachment motion was initiated on 6th of August 2025. In respect to the old complaints, which is constituted of these particular 3 items, the first one is the issue of Kasim Tani. The second one is the issue of Londiani accident. The third one is the issue of private land. Our first attack on that, Mr. Speaker, sir, is that the standing orders of Kericho County prohibited and prohibits the need to consider those allegations. The standing order number 70A subsection 2 is to this effect. Despite paragraph 1, probably I should read from paragraph 1 for context, 70A says this: a motion by any member for the removal of a county governor by impeachment may be reintroduced in the county assembly on the expiry of 90 days from the date of a vote by the Senate. Subsection 2 is to this effect. Despite paragraph 1, a motion for removal of a county governor by impeachment may be reintroduced in the county assembly on other grounds other than the initial grounds that were highlighted in the previous impeachment proceedings. Mr. Speaker, sir, and honorable senators, I put a lot of premium and emphasis on the use of the word grounds that were highlighted in the previous impeachment. Mr. Speaker, sir, it is our contention, contrary to what Honorable Rogon said when he was testifying, that to the extent to which those grounds were captured in the motion, were moved in the county assembly, were debated in the county assembly, were voted for, and were brought here. To the extent that those things happened, they had fitted into that word of highlighting. And for that reason, Mr. Speaker, sir, and honorable senators, it is our submission that indeed it should not be here. However, I would like also to make supplementary comments about those allegations in our defense. I would like to start with the issue of Kasim Tahani. And my learned friends for the county assembly said that the Kasim Tahani was rolled out without proper legislation and that some funds were lost. May I just explain that Kasim Tahani was a concept where the Kericho County Executive proposed that successful bidder contractors were obligated to engage local youths and women so that they would benefit from the contracts that were run in their neighborhoods. And so the payments for the youths and the women was to be paid from the remuneration or the payments due to those contractors. So it's not like it was funds from the county. Absolutely not. It was funds that were payable as part of the contract money. In that situation then, there was no need for any policy, there was no need for any legislation to have been in place. So that's our first answer to that allegation. The second explanation that we have is that indeed in our response both in September 2024 and in this time round, we explained and provided lists of youths and women who are paid on those projects. We are aware that similarly the county assembly, through the committee that purported to investigate, came with a list of youths and women. And our position is that there is nobody owed, and if there is any amount that is owed, they should go to those contractors. But significantly related to that that allegation that there are some people who have been deprived of their due payment, it is our contention that the Senate is not the forum for their claim for labor rights. If they had any complaint about their rights for work done, they should have gone to labor court or should have reported to the police or even gone to civil court. And to that extent, therefore, Honorable Senators and Mr. Speaker, sir, we are contending that the issue of Kassim Mtaani as a ground for impeachment is a red herring. The issue of Londiani accident, we already explained, and I would like to explain again, that it was the committee and the activities of that committee were in the hands of central government. They were not in the hands of the county government. And the person who was chairing those proceedings was the county commissioner. The signatories to the accounts was the county commissioner and members of those committees. And Mr. Speaker, sir, when I asked the question to the witness who came to bring that issue, he admitted that indeed the governor did not sit in that committee, was not a signatory to those accounts, and there is nowhere where he is associated with those funds. It is also significant that the witness says that much as these things happened in 2023, they have not deemed it necessary to complain either to EACC or DCI or to any other entity if they were aggrieved about these funds. And so it is our contention that this issue has been brought solely for purposes of injuring the good name of the governor. Two last issues I wish to mention about this Kassim Mtaani issue and Londiani is that they relate to the period, the financial year 2022-2023. And Mr. Speaker, sir, as we pointed out through when we asked the questions to the witness who came to testify on this issue, it is true that it is not captured in the Auditor General's reports, so that if it were to be the case that indeed any money was lost or there was any impropriety, our expectation is that it would have been captured. The fact that it is not captured is an indication that indeed these allegations are completely baseless. I would like then to come to the allegations that were brought to the County Assembly on 5th of August 2025. And before I discuss the particulars of our defense in respect to that, I would like again to invite the Honorable Senators and Mr. Speaker, sir, to the point we made in regard to that issue. The first one we made was that the governor was not given an opportunity to react and act on those reports. And the witness admitted that the reports were made on or around 5th of August 2025, and the motion, actually, let me correct myself. He said the reports were brought into the Assembly on 5th of August. And those reports provided for a period on average of 28 days within which the governor was to act. However, the next day, before the expiry of the 28 days, and in fact before the expiry of even 1 day, on the 6th of August, the impeachment motion was initiated. And it is our contention that that is an indication of bad faith and political motivation in this impeachment initiative. It is our contention also that if the governor were to be looked at as having failed in his oversight role, he needed to have gotten time to act and to have failed to have acted. Now, discussing the various the various items of that those new allegations relating to NAV, CDP, FLOCA, and strategic infrastructural projects, the allegations of dismissals, we would like to explain that particularly FLOCA and NAV CDP are projects that are foreign funded. They are donor funded projects. Each of those projects have clear budget lines, they have clear work plans, they have cascaded means of ensuring that there is accountability, both even on issues of procurement and audits of works done. And to the extent, therefore, that the works are going on and that subsequent works cannot proceed until the previous one has been audited and accounts provided, to the extent, therefore, that those works are still going on, is an indicator that those projects are in good shape. However, the governor takes the position that if it were to be the case that there is any impropriety, he needs time to look at it and to act on them. But otherwise, he insists that there is no impropriety, and that if there were any improprieties, the donors who are supporting these projects would have raised it. The complainants who have come to you would have even written to the EACC, which they have not done. On the other projects, including the strategic intervention projects, the issues of contract, the issues of procurements, the issue of splitting contracts, the issue of public address, the issue of tents, and the other house renovations, Mr. Speaker, sir, the governor maintains that he needed time to look at it and to act. The fact that the report by the committee came on 5th and he was being impeached on 6th is such that it deprived him of an opportunity to counter-check the allegations contained in those reports and to have acted. But collateral to that, the governor in his affidavit has explained that indeed he has already handed over documents related to, or rather he has instructed his people to hand over the documents related to those projects to the EACC for further investigations. And may I say also related to the old cases, that is Kasim Tani and Londiani, the governor has also, the issues are under investigation by EACC. And secondly, through the witnesses, we were able to show that most of the people who were involved in those activities, in those projects, have been either subjected to disciplinary proceedings, and some have been required to retire. And for those reasons, Mr. Speaker, sir, it is our contention that there is no nexus whatsoever between any improprieties related to funds, procurements, and the other allegations raised between the governor and those situations. I would like to address this issue of the private property the same way we did when we raised it at the outset. The property that is being referred to is not private property, it is public property. And governor insists that it is private property and is determined to recover it. There is the contention and purport that there is a court determination saying that that is a private property. As we pointed out, and consequent to our pointing out, the county assembly has shied away from showing you the judgment. The decision that was made by the court was that the ground should not be used as a dumping ground until a NEMA certification is obtained. There is nowhere where it is said that it is private property. And even if the county assembly in its totality were to try to team up with this person who is trying to grab public property and use impeachment as a threat to the governor to cede the quest to recover the land, the governor is determined to recover the public land. Now, I would like then to answer a few questions that have been raised, especially in the course of the submissions today. The first one is the issue that my learned friend, Mr. Angoya, has extensively referred to, the issues of the joint affidavits, one by both Martin and Edna, and the other one by the 18 MCS. And Mr. Speaker, sir, I had earlier on taken the position that it is proper to have signed a joint affidavit. However, even if it were to be the case that there is any impropriety or any compromise of the impact of those affidavits by reason of joint signing, it is our position that each of those witnesses came here, took an oath, and testified. That is good enough to supplement any shortcomings in those affidavits, and that their testimony is solid to the extent to which they took oath and testified here. The allegations of negative comments made in reference to Geoffrey Bate are denied, and in the course of the testimony of Mr. Geoffrey Bate, he agreed that he has not taken any action if he was aggrieved. He has not complained to the Public Service Board, who are his employers. He has not reported to any police station. He has not reported to any labor court. He has not reported to any civil court. He has not taken out any constitutional action. And therefore, it is our position that it is not true. And if it were true, he would have taken action. And as honorable senators may have seen, he clearly was strongly willed, and if indeed it was true that these allegations were true, then he would have already made a complaint. The other argument that has been made by my learned colleagues for the county assembly is that by reason of not calling these witnesses, the governor is shielding them. As we have explained, in respect to the old cases, Kasim Tani, Londiani, and the others, the governor has taken action. In respect to these complaints that arose on 5th of August, attendant to which he was, process of impeachment started on 6th of August, he needs time to look at them, and he couldn't rush into. It can't be said that he's shielding them because he needs time to have looked at it and determine if there is any issues and deal with them. And then my learned friend, Mr. Ongoya, made a very funny comment saying that there is a certain impropriety in the governor meeting the MCS. It is our position that there is absolutely no impropriety in the possibility of leaders meeting. And there is the contention, therefore, that the governor met some MCS is completely misplaced. Now, I would like to say a few more things before I go to the next step. The first one is to say, Mr. Speaker, sir, on our preliminary objection, that there is unanimity on all the three experts on the two most material issues. The first one is that they are all unanimous that they cannot confirm whether the three MCS voted. They cannot confirm that. Now, when you juxtapose that with the affidavit of the developer of the software, Mr. Alfred Korir, at page 23, at paragraph 23, sorry, where he says it is simple, accurate, verifiable, particularly emphasis on the use of the words verifiable, secure, and accurate. To the extent, therefore, that he intended this system to be verifiable and accurate, to the extent that we cannot determine who the three MCS, whether or not the three MCS voted, to the extent that we cannot do that, it is true then that this paragraph is bailed out. It is not true that that system was verifiable. The second thing that they are all agreed on the other thing that the witness agreed on is that indeed the records of the county assembly contain details of the payroll and ID numbers for the various MCS, and that if somebody was determined to get them, especially within the establishment of the county assembly, they could get them. With those, in that context, therefore, it is our contention that indeed it was possible for somebody else to vote, and that the three experts admit that if you get those credentials, you could vote. So that there are those two admissions, Mr. Speaker, sir, and honorable senators. Number one, that with the credentials, anybody could have voted for those MCS. And number two, that they are not able to trace back those three votes to the three MCS. Now, the last thing I wish to say, as I spare a few minutes for my client, is that we would like, honorable senators and Mr. Speaker, sir, that you take on board these as you consider the propriety of that system that was used to vote. Number one, we pointed out in the course of testimony that indeed the answer has been edited. It has been edited so that it is not consistent with the audio recording of the events. Number two, it is true that a few minutes before the movement of the motion on 6th of August, by the mover of motion, who, as we cross-examined him, we maintain is in collusion with the Speaker, 6 MCAs, there was an attempt to remove 6 MCAs with a view to reducing the numbers or otherwise to intimidate them to support the impeachment of the governor. Number 3 is the question that indeed there was an option to do a roll call voting. Nobody, not even my learned colleagues for the county assembly, have explained why they could not just take a straight and simple process that could have resolved the issue. And for all those reasons, and then the rush to set up this thing at night and to insist on using it, even when the nays, I'd say, were louder than the ayes. For all those reasons, Mr. Speaker, sir, and honorable senators, we pray as a first line of our prayers that you do find that the system was not adequate to satisfy you that any voting took place and that the 2/3 threshold was met. As a second line, we pray that you do find that indeed no evidence and no material and no grounds have been adduced adequate to place a requirement on you to impeach the governor. With that said, Mr. Speaker, sir, I have 4 more minutes. I would like to request my client to just say a few minutes within that time limit.
Mr. Speaker, sir, and the honorable senators of this great house, the upper house,